All right, hello everyone, and thank you for joining today's presentation in the Practical IP for Natural Sciences webinar series brought to you by the ESLW Institute. My name is Brian Ness, helping facilitate today's webinar. Before we begin, a few housekeeping items. If you have any question during today's presentation, we encourage you to use either the Q&A or chat feature. This webinar will be recorded, and I will send an email this afternoon to each of you with a link to the webinar recording and the slides. For today's presentation, we've narrowed in on some top IP issues for corporations and universities. Our presenters today are Ricardo Moran from the Schwegman firm and Paula DeGrandis from the University of Iowa Research Foundation. Ricardo and Paula, I'll let you introduce yourselves and take it from here.
All right. Thanks, Brian. I didn't realize that that these slides are actually Vikings purple, and we are broadcasting from Super Bowl Central here. So anyway, ladies first. Paula, go ahead and introduce yourself.
Hi, I'm Paula DeGrandis. I've been an IP lawyer for years, and I am bringing to the presentation a mixed background of in-house counsel, technology transfer, and outside counsel experience. And I've worked with Ricardo for a number of years, and anyway, I hope to bring some perspectives.
And thanks so much, Paula, for participating. I can't wait to share your perspective with everyone else out there. My name is Ricardo Moran. I'm a registered patent attorney and principal here at the Schwegman firm. Been here for about 6 years. I've been practicing for about 19 at this point. My primary focus is in small molecule pharmaceuticals, but I do a whole range of work, including industrial chemistry and polymers. So the initial slide says that there's 3 issues, but I decided to be an overachiever and maybe we'll cover 4, okay? These are all topics that are near and dear to my heart, primarily because I enjoy working with people and I like to be a problem solver. So one of the things that we work with, some of the issues that people run into is inventorship disputes. The second topic we're going to cover is just basically hanging on to your IP rights. The third topic will be mining and commercializing inventions, and I think that applies to universities as well as corporations. And cost containment, which I think is in everyone's mind these days. So I'm not going to, some of these slides are going to have a fair amount of information. I think that you can read that information at your leisure. And I'm not going to really cover about what constitutes a joint invention or who would be considered inventors. I think that we can read that. What I'll focus on is just having a back and forth with Paula, just to get her perspective on how, for example, she handles inventorship disputes, or does she run into those a lot? Okay, and but just a couple words on inventorship. I think basically. Joint invention is something where you have 2 people working on the same problem. You don't have to be in the same place. But I think ultimately the question is like, who did what? And does that rise to the level of inventiveness? Okay. And a lot of it, I don't think I need to go into too much detail, but I think, the reason why this all is important is because you don't want your applications or patents to be undermined because you got the inventorship wrong. But also, I think, as we'll see as later topics, being an inventor carries some pecuniary advantages, okay? People get compensated more, aside from their salary, if they are inventors, okay? And so that's why people, get very passionate about this, okay? And so, so that's why it's important, okay? I think that at the end of the day,
Ricardo,
go ahead. Yes.
If you want to go back to the slide, this slide.
Mm-hmm.
I think the fundamental issue that we have, and I think it's across not just academic institutions, but maybe more prevalent in academic institutions, it really goes to that third bullet point describing being an inventor as not just a basic exercise of normal skill expected from one of skill in the art or one skill.
Right.
And I really think that when I saw that slide, that speaks to kind of the fundamental authorship versus inventorship difference.
Mm-hmm.
Where, people, I think most people want to be inclusive and when they look at everybody who worked on the project as inventors.
Right.
And
So-and-so so nice. They should be an
right,
inventor.
and they ran all those gels and they stayed up until 1 a.m. and they came in on the weekend.
Right.
But that's really not the same. It's not the same standard. At the university, we actually we allow people actually to basically have a contract among contributors so that there can be some sharing, even if the people are not inventors.
Exactly. Right.
So there are ways that we try and I guess make everybody happy.
Right.
From that standpoint. But it's definitely, it's tricky to get out there and try and educate people ahead of time.
Right.
What is an author and what is an inventor?
What isn't it? Right. And I think one of the tools, of course, is that you probably use is what you just said. It's like, well, okay, fine. So-and-so is very nice and they worked really hard, but they did, they're not an inventor, but they will be compensated in some other way. And I think that takes the edge off, right?
Yeah.
But at any rate, I think that it comes from, them knowing, who's an inventor, and, at least having the comfort that something's going to be coming their way if they're not an inventor in some instances, right? So I think that education, in other words, I think is is what really gets you there,
The other thing that I find that people, it puts people in an uncomfortable position if you're asked them who are the inventors. And so I also use that as an opportunity to say, it's not your burden to figure that out.
Mm-hmm.
Why don't you just tell me contributors are?
Right.
And then after the patent gets written, we can revisit that. We can revisit who's the inventor.
Right. But I think that it's probably important to say to inform these folks at least that the what is inventorship, who's considered an inventor, and that it's a legal determination, and that maybe somebody like me, can be the bad guy. It's like, okay, well, our outside counsel is going to make that determination, okay, and then Paula, you come out looking great. Because I'm the one who makes everyone angry. So, but I've had those situations where I've had to come in, ask all the just the factual questions, and then run it through the law, and then make some determinations as to who is and who isn't an inventor in some contested cases. But those are few and far between. But I think
that is really, to me, one of the outside counsel could be so helpful.
Right.
Of course, we have to maintain the relationship going forward, and it can be difficult from the inside to really get too involved.
No, that's right. That's right. So, my best practices tip here is that just educate your inventors or your contributors, okay, about what makes an inventor and what does not, and then but perform these analyses and this education early on. So one of the other, the next two topics, we're going to switch gears a little bit. We're going to switch gears to talk about some of the vehicles that, some of the issues that people run into in retaining their IP rights and what tools they've used, okay, to retain those rights. And we're going to go through some tools that are better than others, okay? And then we're going to switch into, the last 3 bullet points there. About mining and commercializing, okay? But I think that everyone knows that employees come and go, okay? And sometimes there's a contract that employees sign. More often than not, there isn't, okay? More generally, there's a manual, an employee manual that can spell out IP rights. But generally, it's very vague and nothing is set in stone, okay? And so I think one of the things that people have used to make sure that if something is invented using their resources and their premises by one of their employees is contracts, okay, whether it is an assignment or some sort of other contract, okay. But in any event, you don't want to leave it up to chance that that the state and federal laws are going to be dealing with copyrights and patents are the default, okay. I would advise always people to have something something in writing, preferably an assignment, okay. I don't want to rely on like some ShopRite or that only applies under limited circumstances, okay. One of the tools that people have used is this PIIA, which is a proprietary information and inventions assignment, okay. But oftentimes, those documents are pretty vague, okay, and sometimes they don't have the right language. Like, for example, it might state that the employee agrees to assign, but it doesn't say and does assign all IP rights resulting directly or indirectly to the company's product or service, okay. So, I think that these things are great. They're great if you implement them, but terrible if you don't, okay. So I always go back to just have somebody sign an assignment. Anything to add there, Paula?
Yeah, I was just going to say, yeah, I think that, we do a pretty good job around here. If we know about some intellectual property, we do collect assignments. The workforce here, the facts are pretty transient.
Mm-hmm.
So we get actually some really interesting relationships where somebody just comes and visits and works here, visiting faculty. And so for us, there are some challenges as to does the typical manual that we have apply?
Exactly.
So we do try and address, and I think it is pretty clearly addressed in our policies. I would think that for us, maybe issues of we don't really necessarily know when people leave.
Right.
It would be certainly handy if we could have a meeting with them before they left to say,
right.
Hey, just remember that if you invented it here,
it stays here.
Right.
Yeah. Right. But
it's I think in a corporate setting, it's much easier to have a coordinated effort with HR, and you can actually, just make a systematic process out of
right.
interviews and things. But for us,
right.
it's a challenge.
But you know what? The other challenge that I just thought of is that more and more universities are having spin-offs, right? Some sort of like some sort of corporation that they spin out, right?
Yep.
And I would think, and I always advise, when the university is asking me to represent them and the other guys, the corporation that they've spun out, I mean, it could get kind of tricky, right? Because the professor might say, well, I haven't assigned anything. Do I have to assign? Have I already assigned? You don't want to be on both sides of that conversation. No. It's always better.
I struggle with that as in-house because they're sitting in front of me as an employee.
Right.
In which case, then we're both working for the university.
Right.
But then at a certain point, that relationship is divergent.
Right.
I typically, since I've been here, we haven't really set up an outside counsel situation like that because I think it's too compromising. You can't really do that.
No, yeah, and you could land in a very difficult position as outside counsel, right?
Yeah.
So
I always say, go get an IP attorney.
Yeah, that's right. That is absolutely correct. The other things that people have relied on are these employee manuals, but as I said before, they may be good because they educate employees, right? That there are IP rights that they could accrue that at some point, they might have to hand over. Okay, so it can help to reduce disputes. But again, as an employer, as a corporation or university, I wouldn't want to rely on this employee manual as my sole source of the transfer of IP rights. Okay, you're really grasping at straws if you're doing that. Okay, So the best practices here is, in my view, is get an assignment. Get an assignment that you can record. You file with the patent. You record with the patent office, and it transfers all rights, including the ability to claim priority. Okay, which is a separate right. Okay. And people might say, well, okay, so aside from the university or organization owning these things, who cares? It's like, what if it doesn't matter? Well, you can lose a patent later, okay, if, for example, the person who's actually applying for a patent application doesn't have the rights, doesn't have the right to claim priority, let's say, for example, okay? And what ultimately might happen is that you could lose your priority, okay? Which is something that happened very recently to the Broad Institute, that is, to the Broad Institute. And it's a situation where it was unfortunate, and it's all out there in the blogosphere, is that they lost their priority ultimately because of lapses in assignments. Okay, and so that's a big deal, because that was the CRISPR patent that they lost in Europe. Okay, so that's a big deal. Not only do you want to retain rights, but you also want to make sure that all the rights transfer all along, so that there's not an issue later where you might lose your right to claim priority. So, like I said before, we're going to switch a little bit here to invention mining. And Paula, feel free to jump in anywhere here, because I think that one of the things that we're always interested in is helping our clients develop their IP. Okay, whether it's finding it, and that's what this deals with. Basically, we want people to know what would be considered inventive, so that professors are actually very humble sometimes. They'll be like, yeah, no, I thought about this tweak, but I didn't think it was an invention. And I think that that's where we come in. We want to make sure we capture those moments and are able to continue building the picket fence for our clients. Okay, so I think go ahead.
It's a challenge in a university, maybe at a smaller university. This is my only experience in a very large university, but really there isn't really a communication network,
right?
To really get out there, because I really do believe it's making connections with people in different departments, having positive experiences.
Mm-hmm.
Those people turn around and talk about their positive experience, and getting in. I've gone to the med school. I've given different talks and in different forums, trying to get the whole innovation message out. And I think the University of Iowa is doing like a big push on innovation, and I think things are going to basically elevate kind of the general awareness.
Right.
Yeah.
And I think the University of Minnesota also has regular events like that.
Yeah. I always thought that the idea campaigns, at least I don't know what how they would work in this setting, but those are really great to get people kind of working together as teams, and
right.
The topic and driving up ideas around the topic.
And I think that one of the things that I wanted to touch here, Paula, is that I think, because it might be too obvious, it's worth mentioning. I think that it's good to incentivize your contributors, right? So that they will innovate, they will recognize innovation, and the reason why that is important, particularly in a university setting, is that you will have patents mean that you have property. Property means that you can raise revenue because somebody will be interested in that property. Licensing revenue is very important, and so I think that the more you mine, the better it is. And also, like we talked about before, I think those last two bullet points there that says that at least in Germany, Japan, Great Britain, and Scandinavia, and probably a whole host of other countries, there are pecuniary incentives for innovation, so that people are continue to innovate.
Yeah. Yeah.
And so, okay, so I think one of the things that you and I have discussed offline has been just the challenges about, okay, so we have all this IP, right? It's fantastic, but we have to find a partner, okay, so that we're not going to commercialize it. The university is not in the business of making widgets, let's say, for example. But an auto company like Tesla. Tesla is in the business of making cars, in innovation in batteries, innovation here, innovation there, right? So I think that's the next step. And I think that one of the things that I try to do in my practice in any event is just always keep my eyes open, read as much as I can, and try to see if I can connect people. Okay, people who are who might mutually benefit from being connected, right? And so, I think one of the things that you can at least try to do is, sometimes to the extent that it's possible, leverage service provider contacts for introductions.
I think that's an area where we could do at the university a better job, trying to be more organized about that, and
yeah.
basically have the dialogue going, because we certainly do have a variety of providers that would be helpful. And
right.
I get offered many times for people to come and give seminars here from private law firms, and I usually ask, well, what industry contacts do you bring?
And the one thing I've actually asked people from sitting at the other side of the conversation, Paula, is that do you have a number of key portfolios that you consider to be of high value? Okay, and can you tell me which ones they are, so that I can maybe think about who I could put you in contact with to peddle that. But at the same time, it would be nice to know what the technology is, but a nice summary that you can put together. And Paul, I'd like you to speak to this. It's like I have sometimes asked clients to put together a summary of those portfolios.
We're just starting now to engage with a company that is going to help us write some of those summaries. For us, it's like turning to your neighbor who's already overwhelmed with work and saying, "Hey, could you write some summaries?"
Yes, that's right. That's right. No, that's right. And I think that's, for me anyway, has been a big hurdle, because you guys are really busy. We're all really busy, and for me to ask you to put that together, you to sit down and do it, it takes time, and you're like, gosh, I got 100,000 other things to do. Okay.
Right.
But I think that,
like for instance, doing the commercial part, and then maybe getting the like a sentence summary from you.
Right. Yeah.
About IPs about.
Yeah, and I think that would be fantastic, so long as you identify it and you say, hey, look, these are the 5 patents that we're looking to license. Okay, can you just come up with? I mean, it's going to have to be a single page. Okay.
Right.
It's going to be single page, high level. Can you share the company that you're using to prepare some of these summaries, or not yet?
I don't know how the relationship is, if it's cemented yet. So
then no worries. Yeah. So best practices when it comes to retaining rights, and also to commercialize. Okay, is I think that at the end of the day, no, hang on a second. To mine, also to retain rights, but to mine inventions and also to commercialize them, the best practices, I think, is like what you've been saying, Paula, is you have to talk to people, develop a rapport with your clients. Okay, you have clients; they're your professors. In-house attorneys have clients; they're the engineers and chemists and other folks, FDA folks, regulatory, all kinds of people. You develop a rapport with your service providers, right? So that we can, I think we can help each other out more than just, okay, well, I'm just going to use you for this one discrete task, write that patent application or write that, office action response. And, at the end of the day, you as an in-house person, you need to get out there and develop a rapport with potential licensees too. It's like dating, right?
Yeah.
You're not gonna get a date with anyone if you stay at, well, maybe in this day and age you could get a date by staying in your house, but at the same time, I think if you don't get out there, let's say just the general get out there, you're never gonna find a potential licensee. They have to know you're alive. All right, so probably, this is actually a touchy subject, cost containment. I want to touch on a couple of things here. I think that cost containment has become increasingly important. It's always been important, but I think that it's become increasingly important post the Great Recession. Okay, and I think that we have a tension that exists now more than ever between cost containment and quality control. Okay, people want to pay less and have the quality remain high. Okay, and I think that there comes a point where and I'd like you to tell the anecdote you told while we were talking offline, because that it's fascinating because it happens.
Well,
right?
I noticed coming here, we have for one reason or another, we had quite a large number of firms working with us, and you can really take a patent application that you asked to be written for $3,000, and you can put it next to another one that what you asked to be written for $3,000, and the quality will be very different. And a lot of times it really relates to the hourly billing rates, even though you think you're getting this fixed fee. When you have somebody whose hourly billing rate is $600 an hour, they will literally be able to spend less time.
No, that's right. That's right. And
these are both $3,000 cases. What you're banking on is that the $600 an hour person is twice as fast at a quality application as the person who would have charged you $300.
But you and I both know that they're the what do you call it? The efficiency is asymptotically related to. At some point, you can't get more efficient, right?
Right.
You can't type any faster.
It's definitely, I think, a challenge, especially for places like us where we don't have huge budgets.
Right. So I want to touch on a couple things here, Paula. I think that everyone's familiar with fixed fee arrangements, but I think that the one point that I'd like to make there is like what you just touched on. I think that fixed fee, not all are created equal. If you have a really high billing rate and a really high goal for that year as an as a outside service provider, you're under tremendous pressure to meet those requirements. Okay, and so oftentimes you're not going to be able to devote as much time as you need to give the quality that is demanded. Okay, some people have shifted to not to exceed fee arrangements. I think that those work well. But I think one of the things that we all have to do, I think, is we all have to pay close attention to service provider invoices, right? I have to look at them to make sure that we're staying within budget. And then I have to make sure that, it does me no good to send out an invoice that is not going to get paid in full, that it's sometimes going to get cut. Okay. So I think that's always not good. And then,
I would also say that communication, and I say this all the time, but I don't really get a lot of communication back. But if we ask for something ridiculous, then I want to know, and so communicating back and forth about, well, this, I could do a lot better on this application, but it's going to cost a few $1,000s more.
Yeah.
Kind of message is really like, I'm listening.
Right.
In my situation, would be listening.
And that comes from that rapport that you have to establish with everyone, right?
Yeah.
The other thing I wanted to touch on, and that's the last thing I want to touch on this slide, is the fact that drafting applications with a global mindset from the very beginning, I think, can save you a lot of money and can help you contain costs. Because I think that what some people sometimes do is they draft a patent application with the U.S. in mind, where you can do, let's say, for example, incorporation by reference. You can put in data that is not included in the application through a 132 declaration evidence. And, that's just not going to happen in Japan or China, right? So you have to be, it's going to cost a little bit more upfront to get all those data in, but at the same time, it'll save you thousands of dollars later, okay? So I think that's a tool that people can use to contain costs as well. The obvious one also is that if there's things that you're not going to use, like patents that you're never going to assert or license, you can either drop them or maybe you can monetize them by licensing them. So best practices with regard to cost containment, do your homework, because not all fixed fee arrangements are equal. Not to exceed might be better, but you ultimately, service providers need to keep a close eye on cost caps, and that comes from a very good communication, like you noted, Paula, between me and you, saying, "Hey, Paula, it's just not going to happen. There's, this application has 600 compounds that we're going to have to put into a genus, and all these syntheses and blah 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 blah. We just can't do it for $3,000, okay? And so, we just have to communicate. Or, as you start a project, you get into it, you realize it's going to be more, and
Okay,
communicate.
That bad. We would not be at 3,000.
No, I know. But communicate with in-house counsel and say, hey, look, I know we said $3,000. I know we said $5,000, but I think that we're going to have to revise that. And I think everyone's just going to be happier that way, because everyone understands what the metes and bounds are of this agreement, and you're gonna there's not going to be any surprises, right? So
Yep.
So just to zip everything together, okay, I think that the tips that I'd like everyone to just take home with them with regard to inventorship disputes, let's say, is to avoid the disputes by doing it early. Okay, it always helps to adjust expectations as to who's going to be in, who's going to be out, and who's going to get what. For retaining, securing rights for the company or university, my advice always is get assignments early and get assignments at every step. Okay. For mining and commercialization of inventions, I think that it's just paramount that you develop a rapport with people, with your clients internally, your clients externally, and get yourself out there. Okay. Fixed fee arrangements we just talked about. Not all of them are created equal. And then if you sometimes get caught in quality deficits when you push those fixed fee arrangements too much. And I think that's pretty much it.
Thanks, guys. We don't have much for questions right now. If you can go to the next slide, Ricardo. Our next presentation is going to be in a couple of weeks, and that's going to be particularly towards overcoming licensing issues for universities. If anyone has any questions, you can feel free to connect with Paula and Ricardo offline. This presentation was recorded, so I'll be sending a copy of this presentation along with its slides later today. I want to thank everyone for joining. Paula, I want to thank you for your time. It was a really insightful presentation. Cheers.